At the same time, me and my son's lives were being destabilized by what was happening in the sealed divorce with Mr. Voitis. The second court record, involving my domestic abuser, Victor Ojeda, became a means of retaliation. Judge Green attempted to make it appear that while he was displacing my sons and I from our home based on fabricated premises in one case, he was simultaneously presiding over a valid custody modification involving Mr. Ojeda. That narrative is simply not true. My sons and I have not had contact of any kind with Mr. Ojeda in years. You would never know that from reading the extensive case record Judge Green created between August 2022 and January 2025. The absence of contact was not because we were violating court orders. It was because we were complying with them. And the existing court record shows exactly why Judge Green's narrative is false. In the spring of 2017, two separate temporary restraining orders were granted for each of my sons. This led to the initial suspension of Mr. Ojeda's custody. After a year-long custody modification, a final judgment was entered in July 2018. Mr. Ojeda lost both legal and physical custody of our sons. He was prohibited from having any contact with me of any kind. The only contact he was allowed with our sons was 2 hours of weekly supervised visitation through a designated supervising group. In January 2019, the court found Mr. Ojeda guilty of domestic violence stemming from his continued harassment and violations of the court's orders entered less than a year earlier. In February 2020, the Missouri Court of Appeals for the Eastern District issued a 10-page opinion affirming the full order of protection entered on my behalf in January 2019. Then, in November 2020, Mr. Ojeda was found in contempt of court for continuing to violate those same orders. By March 2022, a court dismissed Mr. Ojeda's motion requesting a replacement supervisor after the supervising group refused to continue facilitating visitation due to his ongoing noncompliance and concerns for the well-being of our sons. In April 2022, Mr. Ojeda's attorney, Roseanne Haran, filed a motion to vacate that judgment, which specifically acknowledged that Mr. Ojeda had no contact with our sons as a result of the court's orders and judgments. That motion was dismissed by the court. All of this is established history in the St. Louis County court system. Then, in August 2022, during the same period of time, I began formally accusing Judge Green of criminal fraud and deprivation of rights under color of law in my divorce from attorney Rick Voitis. The history of the case involving my known domestic abuser was suddenly turned upside down. Judge Green began issuing orders that asserted the exact opposite of reality. He claimed I was in contempt for failing to comply with an order requiring supervised visitation with a supervisor named Karen Strong. That claim was entirely false. It directly contradicted the existing court record. But once that false premise was introduced into the record, every subsequent motion, order, and judgment began building on it. Each new entry relied on the falsehoods of the one before it, until the record had grown into a massive stack of filings that appeared coherent only if you accepted the original lie. Anyone attempting to read through that record today would quickly become disoriented. The record makes it appear as though my sons and I were participating in an ongoing custody modification, that we were having contact with Mr. Ojeda, and that we were even participating in therapy with him and a Missouri licensed counselor named Camille Reinhold. None of that is true. The narrative Judge Green created in that record is total fiction. The judgment entered by Judge Green in January 2025 describes therapy sessions and psychological evaluations that never occurred. I have never met a counselor named Camille Reinhold. There was never a court order directing me to see her. No medical records were subpoenaed, and I have never been diagnosed with the disorders listed in that judgment. Yet those claims now exist in public record accessible to anyone online. My sons, now 15 and 18, have read it themselves. There is no way to describe what it feels like for a teenager to read a false narrative about their life written by a judge. The record portrays them as participating in contact and therapy with Mr. Ojeda and Camille Reinhold that never occurred. It undermines their credibility. It makes negative predictions about who they will become in the future, all based on the assessment of a counselor they have never had contact with, but who claimed that she had. The entire record functions as a massive smear campaign. Judge Green needed that narrative. Because while he was constructing that public narrative, he had already displaced my sons and I from our home in my sealed divorce with Mr. Voitis, using the same method of fraud.